For those of you who this is your first meeting, welcome, and for those of you who it's not, welcome back. For those of you who don't know, BostonSpedPac is a group of parents, and we're all volunteers. BostonSpedPac exists by statute to advise the school committee on the development and improvement of special education programs in the district. So we advocate for all of the children across BPS with regard to special education issues. We meet regularly with the deputy superintendent in charge of special education. We meet 4 times a year with the superintendent, and then we also regularly attend school committee meetings and give testimony about special education issues. So there's a number of board members here tonight. A lot of them are doing things currently, but if people could raise their hand who are board members to let people know who they are. And if you have any questions this evening, Paula Donnelly is here from the Office of Special Education, along with a number of her staff. And if people have specific issues relating to their child's IEP or their child's educational program, you can speak with someone tonight from BPS about what those issues are so that you can try to get them resolved. And we also have with us this evening the Director of Transportation for BPS. Hopefully nobody has any ongoing issues with transportation at this point, but if you do, John is here to talk with you, and if there's any ongoing issues with regard to transportation at your child's school that you think you should be aware of, he'd also welcome the opportunity to hear from you about that. So tonight's presentation is Basic Rights. It's about special education, and we're privileged to have with us tonight Attorney Pamela Coveney here from the Disability Law Center. Along with her is Hillary Dunn, who's also an attorney at the Disability Law Center. And they're going to do a presentation this evening on basic rights. Pamela will let you know how she wants to handle questions this evening, and the rest of us will be available to answer questions throughout and afterwards as well. So does anyone have any questions before we start?
Translation?
Yep. We also have translation services here this evening for Spanish and for Vietnamese. Does anybody need interpretation that's not already hooked up? Okay. So where's the interpreter for Spanish? Oh, she's at the back of the room. So if you want to head to the back of the room and get a headset, she'll give you a headset. And what about Vietnamese? Does anyone need Vietnamese translation? One? Okay. Where is that translator? This is Patty. I'm going to locate the Vietnamese interpreter,
Okay.
and Pamela, you can get started whenever it works for you.
One quick second, just so everybody knows, any documents we have tonight, if you don't have a copy, if you lose it, they're already on the website under the library right now for under the basic rights section. So the presentation's there, as well as a condensed version of the handouts, all in one easy to access document. And you can obviously take a peek from that as well. We're just going to fine tune some of the translation, I think, at that point. Just 1 second.
John, how long do we have? An hour and a half?
Usually we try to wrap up about 8:30, just to,
Okay. And it's
if the interest is there, we can go a little longer.
hour and a half. We'll represent it. Okay. So the Vietnamese translator is here, and he's available if anybody needs that translation, as well as Spanish. So that's it, right?
You do transportation?
Do you want us to run our own slides, or you're going to do that for us?
It's...
I can.
You
Yeah.
do for me?
Yeah,
And I'll do for you? Got it, okay. All right, showtime?
Where do you want
Yes.
to present, here or there?
You can turn
moves
that
around a
off.
lot in the back, yeah.
I'll send you. And then I'll hide behind this nice lady so that no one will see my hair. Does anybody else have a problem with hot hair when it rains?
Not me.
Not you. All right, fair enough. Okay, showtime. I'm Pamela Coveney. It's my colleague Hillary Dunn. We are attorneys with the Disability Law Center. We are free, and we offer free legal services to people with disabilities. I specialize mostly in special ed. Hillary does special ed and a whole lot of other things that she'll tell you about.
It's not a picture.
We are going to try and get through this whole PowerPoint because we think all of the information you need is basically in here. And we're gonna ask you, if you can, to hold questions until the end, but if we're not clear about something that we're talking about, we need you to stop us before we move on. So please feel free if we say something that we haven't presented clearly. Sorry. This is a list of the handouts that we've given you, and rather than run through them all now, we're going to kind of weave them into the presentation. There's a lot of good stuff in the packet. We've given you some letters as samples that you can write. One of our basic things that we want everybody to remember is that in the world of special education, if you don't write it down, it didn't happen, all right? You need to forget that you have a fancy cell phone that you just upgraded to Apple 6, and you need to forget about your email. There are times when to get things done, you need to write a letter. And it need not be a long letter or a fancy letter, but it needs to be a letter so that you can prove afterwards that you've called something to the school's attention. Slide. I want to start out with eligibility and what the pieces are to get eligibility for a child in special education. First of all, the child has to have a disability, and the covered disabilities are all listed in the statute. So if there's ever any discussion about, no, your disability isn't covered, all you need to do is walk in with that list and say, well, you know, it's right on here. I sometimes hear people suggesting that ADHD, for example, is not a covered disability, and that's simply not true, okay? Autism is a covered disability. Emotional disturbances are covered disabilities, and they're all listed in the statute, so you need not really have an argument over that. Where it sometimes gets sticky is that it's not enough to have a disability. You have to show that the student, because of the disability, cannot make effective progress through the curriculum. And that's where there's frequently an argument, because you know your child better than anybody, and you may say, my child really isn't progressing, and the school says your child's doing just ducky, okay? And there's going to be a discrepancy between the way you see it and the way the school sees it. What needs to be emphasized, and I would stand on that chair if I could get up on there because it's really important, is that effective progress is not only grades. It's not only academic progress. It's social and emotional progress. So if you've got an A student in your family who's getting A pluses, who's on the autism spectrum, they might be getting excellent grades, but they might not have any friends, they might be having meltdowns, they might not be able to look anybody in the eye when they're talking to them, they may not have any social skills at all, but they're passing their courses. And the school may say to you, your little boy is a genius, your little girl is very smart, she doesn't need special education services. And if you can show that there's a social and emotional problem and the child isn't making any progress, it is inaccurate for someone to tell you that your child should not be considered for special education services. And that's extremely important, because we get lots of parents who say to us, my child is passing all of his courses and they turned him down for special ed, but I know that he's got some issues. Next. These are the listed disabilities in the statute, and they're in different kinds of categories, but you can see that there's a learning disability, there's emotional impairment, there's neurological impairment. So there are lots of kids who fit in one of these categories who are getting good grades and who are very, very smart. So you need to be very careful that you get a diagnosis from a qualified doctor who says in an evaluation or in a report that your child has one of these disabilities. Because as you can see, some of them you can see from the outside. Most of us are going to know when somebody is blind, or we're going to be able to tell when somebody is hard of hearing. A learning disability is not as obvious from the outside, okay? I have an uncle, for example, who doesn't really read, and some of the people in the family didn't know because he manages, you know, to just cover that pretty well, all right? And unless you stick something under his nose and say, please read this, you're not going to know, all right? So you need to be aware that it's not just enough for you as a parent to suspect that your child has a disability. You need to come up with some kind of proof from a qualified, credentialed professional, and that's a very important thing to have when you advocate for special education eligibility. Next. So we got, again, and we just did this to emphasize what effective progress means. The regulation in Massachusetts is very clear that it's academic progress and social and emotional progress. And please don't let anyone suggest anything different to you. Next. Okay, first step, when you want to get your child evaluated for special education services, you must ask in writing. The law changed. Years ago, you could just say to a teacher in the hallway, I want my son tested, or I want my daughter evaluated. That is no longer the case. You need to write a letter. And we've given you in your handouts just a sample. I mean, you don't, obviously, this is not the Bible, you don't have to follow the script, but you just want to have the basic information in here and make certain to put some contact information on how the school can reach you by way of a cell phone or of an email address. But you must ask in writing for your child to be tested for special education services. There's a form that you need to use that you can use this form right here in your hand, or you can download it on the website for the department, from the Department of Elementary and Secondary Education. This is the best way to ask for a test for your child. And the form is a little slick in my opinion, because in the top part, they've got some evaluations that are already printed in. Psychological and an observation and a health assessment. And a lot of people think those are the only kinds of tests that you can get, and that's not true. If you look at the bottom half of the form, there's a spot down there where you can write in evaluations that you think your daughter needs. So your daughter might not need an educational assessment or a psychological assessment, or she might need those, but in addition, she stutters, or she doesn't articulate clearly, or you see that she doesn't hold her pencil very well because she doesn't have the,
Fine motor skills.
say it again.
Fine motor skills.
Thank you very much, ma'am. The fine motor skills, okay? And she might need an occupational therapy evaluation. And you'll see that's not on the form. But you can write that down in the bottom. There's a space there that says, I additionally request the following assessments. And you can write an occupational therapy, you can write speech therapy, you can write an assistive technology. We've got some clients who aren't able to speak, for example, and there are these fancy iPads where you can put all kinds of software on there, and the child can press a button and say, I'm hungry, you know, may I have a sandwich, all right? They didn't have that when I was in school in the 1800s, but they have it now, okay? And we want you to be able to take advantage of that. But you need to have your child tested, all right? And this is the form that you use. It is critical that you sign this form, you date it, you make certain that the school gets it, and you keep a copy of the version that you have signed. So if there's any discussion later on about, well, we didn't get the form, you know, you've got a copy. The clock starts running from when the school gets this form. And from the day that the school gets the form, they are supposed to try to get the evaluation done for your son or daughter within 30 days. Now, as a practical matter, that sometimes doesn't work out because some evaluators have really long waiting lists. I'm trying to get a neuropsych eval for one of my clients, for example, and the evaluator's telling me, you know, come see me in February or March of 2015, all right? That's my earliest available opening if you're lucky. But they're supposed to try to get it done in 30 days. I like to tell people for really important stuff that it is better to mail this form, and it's really better to send it by certified mail. That's a nuisance, and I'm well aware of that, but I don't like arguments about whether somebody got something, all right? And if I take the time and go to the post office and send it certified mail, and somebody signs for it on the other end, that's all the proof I need. And I don't have to listen to somebody saying, well, you say you sent it and I don't have it, all right? So that's just a thought, but at a minimum, if you're really into hand delivering something, you need to go with an extra copy and get somebody from the school to date stamp it so that you can prove that you delivered it to the school and the school received it on that date. And there's no basis for them to tell you that it's not convenient to do that. It is essential that you be able to prove when the school got this form. So you want to write in any evaluation that's not already on the form. You want to sign and date this, and you want to keep a copy before you send it off. Slide. Okay, we're going to talk a little bit about the team meeting now. Who's been to a team meeting? Okay, who's been to a team meeting where they got ticked off and don't feel that everything went the way you wanted it to? All right, the lady over there in the orange scarf is going to tell you what to do about that. So you want to listen very attentively to Hillary, because she's got a whole bunch of stuff to tell you about what happens when you leave the team meeting and you don't think you got to, well, it just didn't go the way you want it to go.
It's
For
coral.
the time, I'm sorry?
It's coral.
It's what?
Coral.
It's coral?
No, it's not color of her scarf. Don't worry. It's the color of her scarf.
I'm sorry, it's 7 o'clock and I slowed down a little bit. It's coral and not orange, all right. This goes on all day long in the office. You know, it's like Mutt and Jeff. Okay, the team meeting, here's what the team meeting is about. This is mandated by law. It's like any other team, you're a part of it, but you're not the quarterback, okay? You will not be empowered to make the final decision, but they must invite you. They must listen to you. If the team is going to speak English and that is not your first language, you have a right to ask for a translator. You should ask for a translator in advance and in writing so that they have time. You can't walk in that day and say, I speak Lithuanian and I don't understand you, all right? But if you give them a heads up, they are legally obligated to provide a translator for you. If they don't have a translator, it is perfectly appropriate for you to tell them all to have a nice day and to go home, all right? And to write a letter to them and say, I want to reschedule because I cannot participate in a meeting where I don't understand what's going on, all right? It is essential that you write the letter to tell them why you didn't participate. Just don't get up and get mad and go home, all right? But it is an absolute legal requirement that they enable you to participate meaningfully. And that language is right in the regulation, that parents have to be given an opportunity to have meaningful participation. These are the people at a minimum who are entitled to be at a team meeting. Obviously you, somebody who represents the school district, not the school, the district, who is empowered to make decisions on behalf of the district, a special ed teacher, a regular ed teacher if appropriate, and anyone you want to bring who knows the student, the babysitter or the bus driver or a doctor or a therapist might have important information about your student, and you're entitled to bring that person to the meeting. It's considered good form for you to tell the school ahead of time so you don't come in with 30 people and they don't have enough chairs, all right? But you are supposed to be allowed to bring anyone who has unique knowledge of your student. Slide. And I've already talked about this with respect to the translation. This is very, very important, and I hope that you'll pass on the word to people who aren't here tonight, that you need not sit in a team meeting and not understand what's going on because English is not your first language. Slide. Okay, if the team says no and refuses eligibility, they have to say it in writing. And that's not very easy to read, but handout C is the form that they're supposed to send you, and they're supposed to tell you on the form what the reason was. They're going to say they found no disability, or they're going to say your child may have a disability, but your child's doing just great in school, all right? But they must give you a reading. I'm sorry, I misspoke. They must give you a reason and tell you what the decision was. And then you, in turn, need to write back to them and say I disagree, all right? And go on record as saying so. All right. This is my favorite topic. I just learned about this year, so I'm really just very excited with myself. When the team does an evaluation, it's going to conclude something, and it's going to say your student does need help and maybe just needs a little bit of help, and you disagree, okay, with the outcome. You disagree with the result of an evaluation, and you want the team to do another test. You have an absolute right to ask for your student to be reevaluated. And in my opinion, this is kind of like this hidden weapon that people just don't know about. I didn't really use it effectively for my clients until I really had to sit down and write a chapter about it and really learn what the statute says. The statute is complicated, but the important thing for you to understand is that you have a right to request that your child be evaluated again, all right? So suppose you think, because you live with your child 24 hours a day, that your child needs speech therapy. And the IEP team tests her and says, no, speech is just fine, she doesn't need any services. And you just simply disagree with that. All right, slide. You have a right to request an independent educational evaluation. And we call them IEEs for short. And there are two kinds. On the left is what I call type 1. And these are automatic rights to have an IEE. If your child is eligible for free lunch, if your child is eligible for reduced lunch, if a child is a ward of the state or has a surrogate parent, there is an automatic right to another evaluation. It's a no-brainer. You ask for it, you get it, all right? The hitch is that you can only ask for the IEE in an area where the school has already tested. So if the school has tested for speech and language and you decide that you want an occupational therapy evaluation, you don't have an automatic right to get it. You have a right to ask for it, and I'm going to explain how you can get it, but it's not an automatic right. If the school tests in speech language and comes to a conclusion that you don't agree with, you have an automatic given right to request and to obtain an independent educational evaluation. You must ask in writing. The team must do it. They have no option to say, no, we don't want to. We think our evaluation was just fine. And then they have to meet afterwards to consider the results of that evaluation. Now, on the other side, suppose that you're not income eligible, that the student is not eligible for free lunch or reduced lunch, or suppose you want the team to test in an area where they have not already tested, okay? So they did a speech language, but you want an occupational therapy because the fine motor skills are not good, and you see that your child's handwriting is just wobbly, and he or she might need some support. You can still ask for that test, but this time, the school has a right to say no. If the school says no, however, they have to hurry up in 5 days and go to the Bureau of Special Education Appeals and to justify why they're saying no. And then the Bureau of Special Education Appeals, which Hillary's going to explain to you later on, will decide whether or not you or the school are right. So once again, on the left-hand side, if you ask for a retest in an area where the school has already tested, and you meet these other criteria, the free lunch or the reduced lunch eligibility, you have an automatic right, and the school doesn't have a right to object and to go to the Bureau. On the other hand, if you're asking for a test in a new area, the school has a right to say, no, our test was just fine, and we don't need to do this additional test. But then they must allow the Bureau of Special Education Appeals to make the decision. On the left-hand side, that automatic right means that the school pays for the eval, and you don't pay anything, all right? On the right-hand side, the school will pay if it says yes, or if it says no, and then it goes to the Bureau of Special Education Appeals, and the Bureau of Special Education Appeals says the parent was right, we want you to test, all right? In those instances, the test is absolutely free and the school will pay. The problem in Massachusetts, which I don't want to spend a lot of time on, is that what the state pays is very low, okay? So, for example, right now, I'm trying to get a neuropsych eval for one of my clients, and the person I'm talking to do the test his fee is $4,000, and the state rate is $899. So you see, I'm got a little bit of room in between there. But there are circumstances, before you run away, there are circumstances where I can show that if I've made every effort that I can to find somebody who will accept the state rate, and everybody tells me, don't be silly, I won't do it that cheaply, my client might qualify for what is called unique circumstances. And then we might be able to go to the Bureau of Special Education Appeals and to argue that the district has to pay the higher rate. So to walk away from here with an understanding of this, please just be aware that you have a right to ask for your child to be retested. Okay, if the team says, sir, loud booming voice.
Under type 1, my daughter's school, and I gather a lot of elementary schools, at least in Boston public schools, provide free lunch automatically to all students. So like we didn't get an income declaration at the beginning of the school year to fill out for my daughter. How do people in those schools know whether they qualify for type 1 or not?
To be income eligible, you have to make less than, I'm sorry?
I'm from the system in Boston. We don't do the income. If you request an independent evaluation, we don't ask for your income verification.
Oh, okay.
We just pay.
Thank you very, very much. Okay, next, please. Okay, this is what happens if you get a good result with the team. The team says yes, your child is eligible. It's got two things to decide: what services your child is going to get and where your child is going to get them. Those are two separate determinations. By law, the team is supposed to decide services first. So you might be sitting there saying, gee, where are they going to send my daughter to school? And the team is not supposed to get there first. The team is supposed to consider what services. And sometimes this happens in two different meetings, because determining the services is so complicated, there's just not a whole lot of time left over to figure out where, all right? But those are the two issues. Slide. All right. This is probably the most important term in special education. Has anybody heard a team talking about FAPE? Yeah, okay. FAPE is an acronym standing for Free and Appropriate Public Education. Years ago, there was a young woman named Amy Rowley who was deaf, and she was very smart, and she was doing very well in school and moving well from one grade to another. But it was determined, this is about 1981, 1982, it was determined she was lip reading, and she was only getting about 40 to 50% of what was being said in the class. If you turn to the person next to you and you say Mike, bike, or pipe, and you don't say it out loud, they're not going to know which one you said, because your mouth moves the same way for all of those words. And that's what was happening to Amy Rowley. She was getting some of what was being said, but missing almost half of it. And her parents wanted a sign language interpreter for her. This went all the way up to the Supreme Court. It's the first case in the whole history of the country to go to the Supreme Court, and she lost. Because the Supreme Court said she doesn't need to hear everything. She was moving effectively from one grade to, I know, ma'am, but that, you know, what can I tell you? I'm 10 times as angry as you are, and then some, and Hillary's even madder, okay? She was moving effectively from one grade to another. She was getting grades that were acceptable. As far as the court was concerned, there was no obligation to give her the very best educational services and to maximize the services and the benefits she was getting. What the school was required to do was to give enough services to make it possible for her to make that were reasonably calculated for her to receive an educational benefit. It's not a standard that I'm happy with, but nobody has yet elected me to the legislature, and that's what we have to live with. So the important thing when you're arguing or just discussing educational services is to focus on whether a child is getting FAPE as the law defines it. Is there some educational benefit? And your burden as a parent or as someone advocating for a child is to say, no, there's no educational benefit. If there's some educational benefit, you've got a harder fight than if you can show that your child just isn't making any progress at all. But the hardest thing for me to say to all of my clients is that the law does not require you to get for your student the very best educational services that are out there. On my side of the table, that's what I want for my clients, but that's not what the law requires. Ma'am?
So just to be clear, the law is that you get the minimum of what it takes for you to just improve for what's accurate or for what is normal, I guess. I don't know. What would be, so you get services up until you're making progress. If you're not making progress, then that's the obligation. So let's say, in the words of one of the special education teachers I've had to publish, he said he would benefit from this service. It's not something that he needs. So does this law apply to what's beneficial and what's needed? Does that make sense?
I think that's a pretty good way of saying it. I think the more I listen to it, the more upset I become. But let me see if I can repeat what you said. The Rowley standard is that you are entitled to services that are reasonably calculated to give your student an educational benefit. I cannot tell you until you get into an individual circumstance where to draw the line, all right?
So it's very gray.
Say it again.
So it's very gray.
Yeah, I would say it's very gray. I think there are lots of people who win this battle, all right? But they don't win it by saying someone would benefit or your idea is better than the school's idea or best practices is to do it this way. And it took me 12 and a half years to learn to say to some parents, you're absolutely right that this would be better for your student, but that's not the law. The question is it enough? And it's going to vary from one student to another. With due respect, it's going to vary from one hearing officer to another. So
Can I just add on to that?
it's a moving target kind of, yeah.
A quick question. So if I was in a situation where I feel and other people feel that my son needs or benefits from a service, would he be at like a disadvantage because it's not something that he needs? And would he then ever be like all the other kids then? Would he ever reach that level of being with the other kids in his classroom because he is just giving the bare minimum?
I don't know, because in many instances not. Amy Rowley was getting about 40 to 50% of what the other kids were getting. And the Supreme Court said it was enough because even though she was only getting 40 to 50%, she was moving from the 3rd grade to the 4th grade to the 5th grade, and she was passing her courses. It is a given that had she gotten the ASL interpreter, she probably would have gotten all A's. But B's were enough. And I can't answer that any better other than to say that your son is not entitled to the best services that are out there. There is no legal requirement that he be on a par with the other kids in the classroom. There is a legal requirement that he make some progress. So your fight, and I don't like to call it that because what's wrong with this whole situation is that we're all fighting and we don't need to. Presumably we're all supposed to be on the same side. It's just that the kind of proof that you need to present is not that, hey, my way is better, because it is in some instances.
Right.
Or, hey, my son could do better if you gave him this, okay, rather than that, all right? Because that's also true. That's not what the law requires. What you need to do is to show he's not making progress. And that's why Hillary's gonna talk to you about IEPs. You want tight goals that allow you to measure something. You don't want something that says Michael's gonna improve his handwriting, because who knows what that means, all right? You want something that says Michael's gonna write the letter W 7 times and stay in the space, all right? I'm comfortably over 60, and I remember vividly coming home from kindergarten and my grandmother saying these are terrible W's, because I was just all over the place, all right? That's concrete, you know, for me to learn to stay in the lines. Not just gee, your handwriting is miserable. So that's another way to attack the same thing. I'm going to stop in a minute because Hillary's got some stuff that you absolutely have to hear. I've got one more to go, I think.
Can I add one piece?
10 pieces.
No, just one piece is to keep in mind that the FAPE standard, your child has to make, okay. For the FAPE standard, your child has to make effective progress that's commensurate with his or her educational potential. So that's where, you know, the cognitive ability part may come into play. So a lot of times we have a kid that maybe has some type of a learning disability, but when they do psych testing, their IQ scores are average, above average, but they're not achieving anywhere close to what would be their cognitive potential. So that's a situation where, no, your kid's not entitled to get A's, but your kid might be entitled to more than he's getting because based on his intelligence level, there should be better achievement. Does that make sense? I know.
And again, this is mushy, ma'am. I wish I could really kind of do it in really clearly delineated lines. None of us who practice in this area are happy with the Rowley standard. Massachusetts used to have a statute that said that the services had to guarantee the maximum feasible benefit. And they saw me coming because as soon as I started practicing special education law, the legislature changed the language, and it's not that language anymore, all right? So somebody just decided that they didn't have to go quite that high. This, again, is another really, really important special education concept that we refer to as LRE, meaning least restrictive environment. The teams are supposed to try to place kids with disabilities in classrooms with peers who do not have disabilities whenever that's possible. And they're supposed to try to add to a classroom whatever supports are necessary to enable a young person with a disability to learn alongside other kids. Whenever possible, that is what the standard is. Separate classrooms, I got you, ma'am. Separate classrooms are only appropriate when the student's disability is such that he or she cannot learn in a general education environment. But when I was a kid, they literally had what they called a health class. It was the HC class, and everybody with a disability was in that class. And they used to march into the assembly separately, all by themselves. It's a dumb idea. Nobody thought anything about it back then when I went to school. It's different now, and the premise is that everybody is in the classroom together. That doesn't always work, as you all know. There's some kids who need specialized instruction, but the goal is the least restrictive environment that is appropriate for the child. Do you want to wait until the end, or do you want it now? Okay, Hillary's got some stuff, so I'm going to sit down. No.
Okay, so before I start, Pamela referenced that I practice in the area of special ed and do many other things, which I think is slightly overselling, but I do a lot of work with adult service related issues, so like DDS, if people are familiar with Department of Developmental Services, or Department of Mental Health. For example, those are some of our state agencies that may provide some services when kids are young, but when they age out of special ed, they become a very important service provider in many people's lives. So if people have older students or questions about that kind of adult service arena, I'm happy to answer those and maybe talk after, but we're focusing on special ed today, so we will talk a little bit about it at one point, but I can stay after if people have specific questions. All right, so what's in an IEP? We're not going to get too in-depth into what should be in an IEP specifically, because neither Pamela nor I had or a PhD or whatever. So I don't pretend to be an expert and that should be writing specific goals and benchmarks and objectives for your child. That doesn't mean we can't pick them apart and say why they might be legally insufficient, but my role is generally not to be writing goals. So, but we do want to just talk generally about what should be in an IEP. I mean, the first two things, I guess, are a little kind of general, but a lot of parents we'll get a lot of parents who keep calling the principal about a special ed issue, and it makes sense. It makes total sense, because that's the main person in that school, particularly if it's a kid that's in, not in a substantially separate class, a kid that's in a full inclusion, or maybe just has a few pullouts, and maybe there's some discipline issues or something like that, and they continually try to contact the principal, even though their questions are really about the IEP or special ed pieces. And maybe the principal is a good person to help, but oftentimes a better person to be contacting if you have questions about IEP, special ed related things, is a person that is listed on your IEP as the contact person at the school. And when you point it out to parents, oftentimes they're like, oh geez, I didn't even see this, and it's on every page of the IEP, but if you didn't know to look for it, you might not see it. Yep, you have a question?
Well, what if the ETF person,
Yep.
I call the ETF the cleaner, but the school has to be in balance when I look at it. I'm dealing with 9 different schools, I have children in 9 different schools. And what I'm finding is that sometimes the ETF is not approachable. They're not listening. And in some cases, in one particular case that I'm dealing with right now, he is profiling. His biases are so, for example, he says, if you really cared about your kid, you would have been at the IEP meeting. See, that kind of stuff is condescending, right? Like, so, that's when you call the principal. When your ETF person spits in your face because he can get away with it, that's a problem. That's when you call the principal.
Yep, that's
and so you're expecting the principal to come together and bridge these gaps. And I think that is a major problem that from many IEPs or ETFs or COSIS, or even the way they run their meetings, they may not have enough coverage for the teachers, and they just don't care about who's at that meeting, and all they want to do is give you information and don't want you to ask a question. But anyway.
Yeah, sounds like there's some difficult relationships there. I think we're kind of talking generally here that just the idea that if your child is receiving special ed services, whether might be on a 504 plan or they're on an IEP, you should be contacting usually the person that in the school that is, special ed services or 504 services. For the student information part of it, this is where there should be, make sure obviously it's accurate, but I think we're kind of trying to capture that there should be the section with parent concerns, the key evaluation summaries, discussion of the student there, important vision statement, all of that is in your IEP, in your student's IEP. Then we have the goals, the benchmarks and objectives, and then services and placement. This is probably very much a review information for many people, but we do just want to talk about what is required to be in an IEP. Okay, next. So some possible services and supports. These are just examples. There may be other ones that you can think of. These are just some examples of possible services and supports that your child might receive. It might be in your child's IEP. I think it's just important to remember that, you know, your child is entitled to FAPE. Your child's not necessarily entitled to, say, speech therapy because you said so. The team has to agree that that's a needed service, and if you're having difficulty getting the team to agree to that, that's where you might need, you know, your own independent evaluation to have some professional support for your stance that you think your kid needs speech therapy and the, you know, school team members don't agree with you on that. Next. All right, so the service delivery grid, this is one of the handouts. It's, let's see, E, I think. I just want to spend a second here just kind of emphasizing this is an important part of the IEP for you to really kind of understand, because this is the breakdown of the specific services that your child is receiving. And where they're going to be worked on and what staff is going to work on them with your student. And you should be cognizant of the different sections of the service delivery grid. The first section, section A up here, if you have things listed in there, you should be aware that those are only they're just consultation services. So maybe the occupational therapist provides consultation services to the special ed teacher 1 times 15. So 15 minutes a week, the occupational therapist is providing consulting services, discussing strategies with the special ed teacher, whomever is implementing the specific goals around occupational therapy. That's just an example, but you know, it's very important to be aware of what's in that section, section A, because it is not direct service. So your child then is not receiving direct occupational therapy services. They're receiving them from somebody else who the occupational therapist is consulting with and talking about strategies, and that might be enough, but it might not be in some situations. So then we have the section B and C. B would be services that your child is getting direct services, but in the regular education environment. C is you're getting direct services, but in a substantially separate environment, a pull-out, something like that. And just be careful, make sure it reads the way you think it should read, double check this before you sign an IEP. You want to make sure it's very clear if, gee, my kid was getting 2 times 30 of speech last year and now this says 1 times 30, why are they not getting the speech that they were getting last year? But it's just important to double check this before you're signing your IEP. Okay, so obviously another issue that comes up is placement. That's an important part of the discussion at your IEP meetings with your team. So Pamela already talked about the least restrictive environment requirement. So this is just an illustration that Pamela did, not myself. She's much better with PowerPoint than I am. So Pamela put this together just to try to illustrate, visually for folks, the continuum of placements and the continuum of the least restrictive environment. This being the least restrictive, a child's in regular ed classroom, fully included, and then a residential school essentially being the most restrictive environment, I guess short of a hospital setting, but generally speaking, special ed-wise residential is going to be the most restrictive. There's a lot of things in between here, regular ed with pullouts, that's partial inclusion. Pullout, these are examples of pullouts. There certainly could be pullouts for other things. Then substantially separate classroom, that's pretty self-explanatory, that's all still within the public school system. When you get out of that to the out-of-district placements, that's where, that starts to be taking a larger step in the restrictiveness continuum. And in out-of-district placement, it could be at a private special education school, the May Institute in Randolph serves a school that services a lot of kids on the autism spectrum, or the Lighthouse School in Chelmsford serves a wide variety of kids, but there's just some examples that they are private special ed schools that are approved by the state to be providing special ed services. An out-of-district placement technically could also be depending how it's set up, a collaborative placement. So I'm not sure that Boston really takes advantage of collaborative placements. So you do sometimes, okay. In the collaborative is really just a bunch of cities or towns getting together and really kind of pooling resources to develop programs for kids that maybe have very specialized needs. So, I mean, it frequently is something that's utilized in smaller town settings, I guess, where you can think that the town doesn't necessarily have as many kids with particular profiles of disabilities, so they have other resources. But that would be another placement that's outside of your kind of local school district. Go ahead. Okay, so here we have the proposed placement. The placement page is handout F. That should be in your packet. Here, I just want to point out, this is the part where the proposed placement is listed. Those are the fancy words for what the previous slide just said. So, you know, it's full inclusion, partial inclusion, whatever. So that's the proposed placement that the school is making. If there is an out-of-district placement in particular, make sure that the school that you think that your child's going to be sent to is written in there. You'd be surprised what comes up and what a parent signs sometimes, and they're, you know, something is looking very different than they thought it would look, and they didn't carefully look at it. Then when we get down here, it's what you do with, are you going to accept the placement or are you going to reject it? Next slide, please. Well, and what we would really emphasize to folks is if you disagree with the placement, or you disagree with the IEP, or you don't understand the placement, or you don't understand the IEP, or you're not sure how you feel about it, you know, you should not feel pressured to sign anything at the meeting. You do not have to sign an IEP or the placement consent form at the meeting. There are times that there is a rushed change of placement, and maybe it's a fairly crisis situation that it's a really bad placement. The kid should be moved as quick as possible. That maybe, yes, you should be contemplating signing during that specific meeting, but the vast majority of times you should be going home, thinking about what it is that you really want to do, thinking about if you agree with this, you don't agree with it, do you agree with parts of it. So just don't feel pressured to sign the IEP immediately at the IEP team meeting. When you're thinking about what you want to do with your IEP, there's 3 ways to respond to it. You can fully accept it, so that means you agree with everything. You agree with how your child is essentially characterized throughout the IEP and the student information type sections. You agree with the parent concerns, you agree with the vision statement, you agree with the summaries of all the evaluations that have been done. You agree with all the goals, you agree with all the services, the frequency of the services, which is in the service delivery grid that we just looked at, and you agree with the placement. So if you agree with all that, great. Accept the IEP and accept the placement. If you agree with some of it, maybe you agree with some services, but you think that he should be getting more in some areas, then you would partially agree with it. Say you agree with the IEP services, and you actually agree with the frequency of the services, but you don't agree with the placement. You say, this would be great, but I think my kid needs an out-of-district placement. Or, yeah, I agree with this IEP, but they don't need to be in a substantially separate classroom, and they should be back in the regular ed classroom for some of these, some of the day. So again, you're kind of in the partially agreeing thing, or you hate everything and you're going to reject it and completely reject it. We find that, you know, if you really do agree with everything, great, accept it. That's wonderful, and that's the goal, is that everybody agrees. That is the goal. But oftentimes there are things that, you know, a parent's going to disagree with. Instead of fully rejecting the IEP, oftentimes partially rejecting it is a more productive way to move forward if there are parts that you agree with. Because if you fully reject the IEP, your kid is not getting any of the services in that IEP. They're getting whatever's in the last signed IEP. And particularly if this is an eligibility, you know, this is your kid was just found eligible for special ed, this is their first IEP, if you fully reject that IEP, your child is getting no special ed services until you resolve this dispute with the school. So for a number of reasons, trying to figure out what parts of it you want implemented and agree with, to accept those and then be very specific about the parts of it that you disagree with and are rejecting. So that's our 3 ways: accept, reject, and partially accept and reject. And this is the page in which you would do that. That page is in your handouts as well. It is, let's see, are we on G? I think it's handout G. Or F? Is this here? F? G. So here is where you can check the box for either I accept, I reject, or I partially reject. Yep, you have a question?
Yeah, when you partially reject,
Yep.
let's say it's for a service that they're offering a consult, as
Yep.
opposed to like, and you feel that they should get more. When you
Yep.
partially reject, does the consult go away too? Or
Yeah,
do
they don't receive the
they
service at
don't
all.
receive the service at all?
Correct. Yes, if you want to get really fancy, and it can get a little confusing, you can respond saying, I reject the consultation, for example, okay? However, for the interim period of this, until we work out this disagreement, I want that service implemented. I am conditionally accepting it. In no way am I agreeing that this meets your legal requirement to provide my child FAPE, blah, 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 blah. Do I think that that's a great way to go? It depends on the situation. And a lot of times, if that's what happens, I end up writing that for my client just to make sure that their rights are protected as much as possible. But for the most part, if you're flat out rejecting the consultation services, they're not getting them.
So what's the difference between rejecting a service and rejecting an evaluation?
The service is in the IEP. The evaluation is a separate document. So we're just talking about the IEP. So as opposed to, say, a psychological evaluation, speech and language evaluation,
You can reject those as well?
you can reject those in the way that you can say, I disagree with the findings. This is what Pamela was talking about. I disagree with the findings, recommendations, whatever, and I'm requesting an independent evaluation. That's the independent evaluation piece that Pamela was talking about
And you
previously.
said you don't do that on the IEP, you do that separately.
Yes. The IEP is, I mean, is there a reason you would be somehow rejecting an I'm trying to think. quickly.
No,
No.
they're 2 separate things.
Yeah.
An evaluation is a test. It's the school subjecting your child to a series of tests. When I say that you reject the evaluation, that's shortcut for saying I disagree with the conclusion of the evaluation. Now, you can say that you reject having the evaluation done to begin with, but that's not what we're talking about. What I'm saying is that there's an evaluation, it concludes something, and you say, I disagree with that conclusion. Hillary is talking about something that's already in the IEP, where there has already been an evaluation, and you don't like the service that they're offering.
Yeah. Okay, yeah.
But I was just gonna point out, I had this situation happen, that in the IEP, any service or consultation that you partially reject, like
Yeah.
let's say, you know, you wanted more speech therapy or something, your child's still entitled to that baseline service that they gave them. And it's just conditional upon them approving them for more, you know what I mean?
Well, they're entitled to what would have been in the last agreed upon IEP.
Yeah, that's what
Yeah,
I'm saying.
so it's not as though, okay, so I guess to maybe
If you're
clarify
rejecting
this.
it, asking for more,
Yes. If
you're
you're
still
yes.
required, you get the baseline.
Right, but if they propose 2, but you thought the child needed 4, you
Yep.
can accept the 2
Yep.
and reject by omission
Yep.
the additional 2 because you feel your child requires.
Yes.
Same thing with the consultation, you can accept the consultation and reject by omission the direct services because you feel the consultation is insufficient.
Yes. That is a much more eloquent way of what I was sort of saying about yours when you were talking about consultation. That was much more eloquent. But, I mean, it's very important that if your child has been on IEP for a number of years, okay, and you go to a meeting tomorrow, you get your IEP, you go home, and there's things that you disagree with on that, and you just completely reject it, they're not getting what's in that IEP. They get in the one from, they they get the services from the year before. So it's not as though they're not getting anything, they just get what was in the IEP the year before that was agreed upon. Okay? Yep.
I'm just trying to understand the violation piece that she was talking about, and the, like, if it's rejected, if you reject, say, the 2 hours, that they're proposing 2 hours, and last year was 1 hour, for example, and I'm saying I want 4 hours.
Yep.
So can I reject, I guess, by omission, that
Yes.
I want more hours, and my child will still get 2 hours, or is my child
Yes.
get that 1?
So you would say, yes, I reject by the omission of these 2 extra hours. You accept the 2 that are in this proposed IEP, but you're not agreeing that that's FAPE. It says, and I request a meeting to discuss this, and with the idea that it would be worked out at the meeting, hopefully. Yep.
So if it's the first one and they say 0, do you reject, or what do you do? And second, since it sounds so complicated, do you recommend that you get counsel and bring counsel with you at all times during this whole process if it's the first time?
Well, in terms of the counsel piece, there's a lot of, do you need an attorney? No. Some people want an attorney for that. That's fine. Maybe you do need an attorney because it's a particularly complex situation. There's other resources. There's educational advocates out there that are very experienced that, you know, if you're going to end up paying for an attorney, you might be able, you know, educational advocate's going to be less expensive. They're not a lawyer, but they might have enough experience to be able to kind of walk through accepting or rejecting an IEP. I mean, there's no clean-cut answer. It really depends on your circumstance. In terms of what you're asking about, if it's the first IEP, I mean, if it's a first IEP, there's going to be some services. It might just be that you think that your kid needs speech and language, and there's no speech and language in the IEP. If you fully reject the IEP, then they're not getting anything, any of the other services. So that's why it's not usually a great idea to do that. So there might be other goals and objectives that completely make sense, but you're really fighting about this speech and language service that you think should be happening.
But you don't want to reject a first
Yeah.
IEP in full, because the
But they say
district will
there's
just forget
nothing
about
there.
your child, and they have no obligation to provide anything
Yeah.
because you rejected what they proposed.
And if they're saying there's
zero
nothing,
services.
well, then
is
they
it-
wouldn't give them an IEP.
Right.
No, if they say that there's no services required in the IEP for, say, speech and language.
Yep.
But the other services come in.
Yep.
Basically, are they saying there's gonna be nothing for the period of time as you go through the remediation process then?
Correct. If the IEP has 0 proposed speech and language, for example, you reject that and say, I think it should be whatever it should be, but he should be getting some amount, then while you're in this dispute period, the kid's not going to be getting any speech and language. So it is an incentive to try to work out disputes as quickly as possible, which is a lovely segue to what we're going to talk about next. And if there's questions because things are unclear and that I'm unclear, and I apologize for that, please ask them. If it's things that can wait till the end, try to wait till the end so that we can get through this. But if I'm unclear, please point it out. Okay, let's keep going. We already talked about challenging placement, the placement consent form. If you disagree with it, then you check the box for I do not accept this placement, and then you probably also want to check the box that says that you want to meet to talk about it. Okay. All right, so let's move on, if that's all right with folks, to situations where there's an IEP in place. You're okay with it, it's an accepted IEP, things are going along fine, you think it's a good IEP if it were implemented. And say, for example, it is not being implemented, so your kid's supposed to be getting 2 times 30 in speech and language, but the speech and language pathologist has been on maternity leave for 6 months, and nobody has filled in for that, so your child has not gotten speech and language therapy for that entire time. That would be an implementation problem. It would be a compliance issue with the IEP. So, we want to tell you about Program Quality Assurance. It is a unit within our State Department of Education. Our State Department of Education is called the Department of Elementary and Secondary Education. And program quality assurance, PQA, is a unit within that. They are charged with essentially enforcing our special ed laws to an extent. They don't conduct hearings. They will take complaints. So you make a complaint. My district is not complying with my kid's IEP. He was supposed to get X number of speech and language hours, and he has missed almost all of those. And here are my notes to show you how I know that he missed all of those. That is something that would be appropriate to file a complaint to PQA. PQA then takes your complaint and they investigate it in the way that they contact the district to, try to see what the district has to say about this. They gather information. They'll probably go back to you to see if you have any additional information to provide, and then they make a finding of either compliance or non-compliance. And if there's non-compliance, then they also have the power to order corrective action. So that could include that the district has to make up the 5 speech and language sessions that your child missed, for example. The next slide. So for Boston,
Is getting the services.
excuse me?
How do you know if your child's actually getting the services?
Get a letter if they don't.
Yeah.
I do, but I'm not getting responses.
I
I mean, my
can't
child's
hear.
nonverbal, so I
Yeah.
can ask him if he got the speech today.
Yep.
I do get the occupational therapist does write on his home book.
Yeah.
Every time she meets with him and what they went over. Other than that, I really have no idea if it's getting the services.
I would request that there be that the OT person not be the only person that is writing down what's going on, and that there be a better communication log that's going back and forth between home and school. But
But as a parent, why isn't it just automatically a process? Why does a parents have to continually fight to get these information? We ask for it once, why do we ask after it, second, third, fourth, fifth, sixth time?
if they're not, then
I
yeah.
understand it's my job as a parent, but as a parent in this, day and age, I have to work, so I have a full-time job and I have kids at home, and if you have more than one kid, even if you have just one child, the process of getting them home, doing their homework, doing all that stuff, and then now I've got to follow up, but when do I follow up? Do I put my job on the line? I mean, it should be an automatic, it should be their job as a special ed
Yep, and
child.
if
With an IEP,
Yep.
they should be required to fill out a weekly form to say, this is what I saw, this is what it is. So I, as a parent, can turn around and say it. I mean, I didn't know
Okay.
we didn't get services the first couple of weeks of school, till I asked.
Okay,
Really?
a
Why
couple,
do I have to
a couple pieces to that. One, it's incredibly frustrating that you have to ask, but I would really suggest talking to your team about making sure some type of home to school communication, maybe like you suggested, a form or a communication log, the home to school, that it is more specifically filled out, that Johnny got this today, Johnny did this today, Johnny did that, so that it's clear. Otherwise, if you're asking and not getting an answer, that might be a good time to file a complaint with PQA. Also, if a school is doing things appropriately and there's going to be somebody, I wouldn't say appropriately, if they're doing it in a parent-friendly, communicative way, if somebody's going to be out and your child's going to be missing services, they oftentimes do communicate that and write it and put a letter. Many times they don't, and I mean it's not a great system all the time, but there's limited things to do sometimes. If you're not getting answers, I'd file with PQAs that, as far as you can tell, your kid's not getting services because they haven't told you that he is, and you're concerned that he's missing services. Make the school then respond to you that they are. Yep.
Just say, Sandra Handig is no longer our.
Oh, she's not.
No, it's
Oh.
Nathan Lemon, and
Okay.
I'm looking up his number now.
Thank you,
okay.
would you? Because that's what the website says, so they have,
I was gonna say they must have
okay, they have it, yeah, because I just looked that up the other day.
Yeah.
Yeah.
Okay, so that's the direct contact person for Boston. Yep, question? Can we go to the next slide?
Do you know how many parents are supposed to be in the classroom with a child with an IEP?
How many paras are, it entirely depends upon what is in each kid's IEP, there's not an answer to that. You mean general staff pay?
Yeah.
You're not gonna know what is in all the other kids' IEPs that are in your kid's class. It's confidential information, so.
Is there like a ratio?
There is a ratio, which I will fully say, I do not know off the top of my head. I have to look up the regulation of what the general ratio is. Is it, do you happen to know?
Substantially separate or
Yes.
inclusion class?
Oh, well then that's even different. I was thinking substantially separate.
And it depends on the age.
Yeah.
With the younger children, it's a higher ratio, you know, we're talking 3 and 4 year olds, and then after that, ratio changes substantially.
Yep.
Here, what depends on inclusion.
Yep. Okay, so we're going to move on because we have a lot of information and some questions maybe could be asked at the end if they're more kind of your personal situation, because we really want to get through all of this as much as we can. There's a lot of information. So we want to talk about now about what to kind of do if you are in these situations where you're not having a successful relationship with the school and you're disagreeing with what's happening, you're not liking what's happening, one reason or another. We have this little movie camera thing here to remind me to say that on our website we have an online manual regarding transition services, and there's a specific part of that online manual that talks about dispute resolution. So if you want to go online and watch a video, and I think it's Pamela that's talking in the video, then you can go online on our website. The link is on our website. So we want to kind of talk about dispute resolution, that it's like a ladder. You kind of start down here when you're having informal discussions with teachers, emails, finding out information. Yep. Is it a question that we, okay.
Regarding an issue.
Yep.
I would like to record it. Would you ask them?
If they agree to let you record it, then you are allowed to record it. If they don't agree, Massachusetts is generally a state that is not going to have you recording it without the school agreeing to it. And I would not suggest doing it without telling the school. And I've had parents that have like secretly taped a meeting, and it just doesn't really end that well. But a lot of times districts will say yes if you ask them to record a meeting. I mean, I caution you on that. Clients ask this a lot, okay? There's positives and negatives to this. You can certainly record what the district is saying. It's also recording what you're saying, and to make sure that you're not getting emotional, that you're not, I mean, you have to really stay in check, because that can really backfire if you have recorded everything and, you know, you have an emotional outburst, which sometimes happens. It's an emotional subject. You're not doing anything wrong, but it's taped forever then, really. Okay, so when you start off in what we call level 1, that's where it's really informal, and you're kind of just disagreeing with what's going on, whether it's services or what's happening in the classroom. You don't know if they're getting services. We would encourage you not to spend too much time here because there are numerous options for trying to resolve a disagreement with the school, and trying to just go back and forth on email or have separate conversations with a teacher is oftentimes not really that effective if it is a disagreement that is not resolved pretty quickly. All right, so moving on, many of you are very familiar with team meetings and what happens there. So if you go to the team meeting, you ask for more services, you ask for a different placement, and that is not successful at the team meeting, and you continue to disagree with the school's position, then you have some options here, okay? And a lot of parents think that if the school says no at the team meeting, that it's the end of the road, and you know, they said no, and what do I do? You do have options. You just have to decide to exercise your rights, basically, which can be a stumbling block for many families. So one option, mediation, okay? The Bureau of Special Education Appeals has mediators on staff. So the Bureau of Special Education Appeals is essentially kind of administrative agency that is in charge of our mediation process, due process hearings in the context of special ed cases. So if you have a special ed dispute that you want to mediate or take to a fair hearing, you're going to be at the Bureau of Special Education Appeals. So mediation, they have mediators on staff. Mediation is free, it's confidential, it's voluntary, so that means you have to agree to it and the school has to agree to it. But what is said there is confidential, and I point that out because if you end up having to go to a hearing down the road because mediation didn't work out, whatever's discussed at mediation, maybe there was discussed of making some compromises on some things, that cannot be brought up in front of a hearing officer. That, you know, if you were showing that you were willing to compromise on an issue during mediation, the hearing officer will not know about that. So what's talked about is confidential. But if you're not able to work things out in mediation, then you're probably at the point where you are going to either want to have already consulted an attorney, or possibly consider that, or you know, if you're able to retain one, then that's great. Right here is where we kind of mark the line that you have to make a decision of what you want to do if mediation fails, and do you want to file a hearing request, meaning you've made a decision that you're continuing to disagree and you want to exercise your rights and go to a due process hearing. So the hearing request is basically like a complaint that you would file in court, but the BSCA is the administrative agency, so it's an administrative hearing. So, I'm sorry, I kind of lost my train of thought. So similar, if you were going to Superior Court, you would file a complaint to start the proceedings. Here, you're starting your administrative proceedings, your administrative hearing, you file a hearing request. We just call it a hearing request, we don't call it a complaint or a petition. Your hearing request has to spell out, you know, what it is that you think is doing wrong, be as clear as possible. This is why we think it's oftentimes good to have consulted or have an attorney when you're writing a hearing request to make sure that it's done as properly. Now, once you file the hearing request, you still have some options to try to resolve this before going to a hearing, which we would very much encourage you to do, because a hearing is not fun. It's very time consuming. It takes a long time to resolve the disputes. So you're talking months down the road from when you initially filed the hearing request. So some options are the resolution session, which is just basically another meeting to try to work things out. I'll spend a minute talking about settlement conferences because that's something that people are probably less familiar with. So the BSEA has a formalized settlement conference procedure where a very experienced administrator there, who was a hearing officer for a couple decades, I think. She conducts the settlement conferences. They are very useful, very productive. Oftentimes agreements are reached through this process. Her success rate is over 90%. The hiccup or catch is that the parties must be represented by attorneys. So that can be difficult because a lot of parents, you know, you can't afford to hire an attorney and there's only so many free attorneys around. But if you're able to have an attorney with you, a settlement conference can be a very useful way to try to resolve your dispute. And a hearing would be our level 3 that, I mean, a hearing is a hearing. It's basically a trial, and they can say it's an informal process. It's not informal, it's formal. It's informal in the way that it's in a conference room type setup as opposed to a big courtroom that you see on Law and Order. But it's formal otherwise. There's a hearing officer presiding over it. You make opening statements, you have witnesses, and if you don't have witnesses, you're going to have a very difficult time proving your case at the hearing. You need to have your experts that eval your kid at the hearing. I mean, this is a trial. You have to have expert witnesses that are questions on direct exam, cross-exam. It is an overwhelming process for many, many parents. And the statistics aren't great. Schools win the majority of the time, which is, you know, not great and doesn't feel great. But if you're the parent filing the hearing request, the burden is on you to be proving beyond a reasonable, not beyond a reasonable doubt, I'm sorry. It's a preponderance of the evidence standard, but you are the one who has to be proving that there was a denial of FAPE, or there was, whatever it is, the placement's inappropriate, etc. But the burden is on you, and that is difficult. If the school files against you, the burden is on the school, but usually it's the parent filing the hearing request. And the school district is always represented. They're always represented at every hearing. So, it's very hard for families, particularly if you're not able to have representation with you. But there's every year a few parents who go pro se, 1, 2, 3, who win at a hearing by themselves. So it's possible, it's just very difficult. Okay, and I think it's back to Pamela.
I want to follow up on what Hillary has said about this dispute resolution process, because one of you raised the question about what if the ETF spits in your face, or what happens when people are just not responsive. What Hillary has just said is just really the whole crux and the core of this whole special education situation. It does not end with the school. And if you climb that particular ladder that Hillary described, that's how you fix stuff. Going to the principal is sort of like, in my opinion, being in Florida trying to go to Maine and detouring through Kansas. I mean, it's a left turn, all right? The process in special education is just what Hillary has described. If it doesn't work at the team level, you either go to PQ&A when you've just got people who aren't listening to you and who are not responding to letters. You keep careful track of what it is that's happening. If you go to a meeting and they don't listen to you, or they don't allow you to speak, you write a letter saying exactly that. I couldn't participate effectively in that meeting because you disrespected me or you interrupted me. A paper trail is the key to all of this. To the lady's question about why would people have to continue to ask when you're getting, whether or not your child is getting service, you're absolutely right. You should not have to ask more than once, and the school should do all kinds of things, but the law just simply doesn't go that far. So until we get better laws, until we all go on up to the State House and make a fuss, we have to live with the laws that we have and fight in the way that we're allowed to fight. And writing letters to document what has happened that you don't like is the first step. And should you have to write 3 letters? No, okay? But that's just the way it is right now. And that is the effective way and the only way I know to work through some of this stuff. And I agree with you that it's not fair, but you're not as powerless as you sometimes think you are if you take the time to go home and write a letter and say, look, this is what you guys did and I don't like it and it's hurting my kid. I want to talk a bit about discipline because it's a mess right now. The Massachusetts law changed in July of this year, so your child gets more rights when he or she is suspended or expelled from school. Under the old law, if your child was not on an IEP, it was legal to expel the child, and the child would not be entitled to any further schooling in the Commonwealth of Massachusetts, and that is no longer the case. So I'm going to walk you through this, acknowledging that there's some questions that we don't have answered yet because the change in the law is very new. The first thing, if the school suspends your child, is you need to look at these questions here so that you're very clear about how many days your child is out of school, and you're very clear about what the reason is. And you want to make certain if the school is accusing your child of having drugs that are illegal, of selling legal drugs, of bringing a weapon to school, or of causing serious harm. And we urge you to be very, very sensitive to all of those areas because the statute is very literal and it doesn't allow for mistakes. We had a young woman who had a birthday and her parents made a cake for her, and all she wanted to do was to share the cake with her classmates. And she went to the kitchen and got a knife out of the kitchen only to cut the cake. That's the only reason she brought a knife to school. But she was suspended because a knife is a weapon, all right? And nobody cared that she was only bringing it for the purpose of cutting the cake, all right? A weapon is a weapon. I had a client who was relatively slightly built, and a larger kid came to him and said, hey man, hold my sweater for me. And I said to my client afterwards, why didn't you say no? And my client said, because he would have met me outside, all right? So he took the sweater, and a knife fell out of the sweater. The law is just about possession. It's not about why did you have this knife, all right? So my client was suspended. So I urge you to check those lunch boxes and to check those backpacks and to have some awareness of what your child is bringing to school. Because right now, in the aftermath of some of what's happened nationally in school, there's just not a lot of tolerance for certain things. And you gotta look out on your end. But these are the questions that you need to be asking. Slide. All right. Massachusetts has changed its discipline law, thank God, and it's much better than it used to be. So under the new law, it is now illegal to exclude a child for more than 10 days. Students have a right to some educational services when they are suspended, and that was not previously the case. So there's supposed to be an effort to enable your student to make some educational progress while he or she is out of school. The school must provide notice of the charges, and they must provide the reason for the suspension in your primary language. And you can request a little bit more time now to appeal an exclusion or to have a hearing before the superintendent. The old law gave you a very limited window, and sometimes people are just kind of reeling from what's happened and they're upset and the time just kind of whizzes by them. But you can write now and ask for an extension. Slide. Okay, there are two kinds of suspensions now under Massachusetts law, short-term and long-term. And the cutoff point is 10 days. If the suspension is short-term, your student is entitled to make academic progress during that period. And what that means is what's up there, making up assignments, making up homework, quizzes, exams, and projects. Under the old law, for the first 10 days, your kid could be out of school, get hopelessly behind. 10 days in school is a long time, and it's very, very hard, unless you don't need to sleep, to make up 10 days of missed homework and exams and projects. You get behind, you stay behind, and ultimately lots of kids are just dropping out of school because there's no catch-up. That's changed now. It's not perfect. It should be much better than it is. This is a brand new law. It literally became effective in July of this year. So what's that, 7, 10? That's like 3 months, all right? So we're all working out the kinks, but this is what your child is entitled to. So even if your child gets suspended, you have a right to talk to the school and say, where's the homework? Are there quizzes? Is there some project that everybody else is working on? And what can you do to make sure that my child gets a chance to catch up? No, I'm not finished with that, thanks. For longer-term suspensions that are more than 10 days, there has to be some opportunity to make up work, but every school is supposed to have a school-wide education service plan, and there's a list of different ways that a child can get educated, so it can be tutoring, or alternative placement, or Saturday school, or online, or distance learning, and you get a chance to pick from that list, and then the school is supposed to help you try to use that particular method to enable your child to catch up. Again, this is brand new. We don't know how well it's working or how well it's going to work, but this is what the law now requires. This is all, I must emphasize, Massachusetts state law. This is not federal law, and this applies to everybody. Kids on IEPs and kids who are regular education students. Okay, here's where it gets interesting. The federal law is different, okay? And under the federal law, if you're a regular education student, you're subject to those laws that I just explained, the Massachusetts laws, all right? If you're a special education student under federal law, you are entitled to all of those Massachusetts services. In addition, for an exclusion of longer than 10 days, the school has to make an effort to determine if the disciplinary violation has something to do with the disability, okay? So, if your child is deaf and burns down the whole school, there's probably no connection between the two, all right? But we had a young woman the other day who has Tourette syndrome. And the tic that she has is, I'm being recorded so I won't use the word, but she uses the F word, all right? And she threatens to kill people, and that's just what she does. It's completely involuntary. She just says the F word over and over and over again, and she'll say, I'm gonna effing kill you, all right? She can no more control that than any of you can control breathing. That's her disability, all right? But when she said that, it triggered the obvious reaction because she's threatening to kill somebody and she's using inappropriate language, all right? She is entitled to what is called, after 10 days of exclusion, she is entitled to what is called a manifestation determination review. And we call that an MDR for short. And what that is a meeting that says, did you do this because of your disability, okay? Is the disability and the conduct, or are they two things that go hand in hand? She's also entitled to something called a functional behavioral assessment. And what that is a kind of evaluation that involves an observation of a student to see what are the things that triggers certain behaviors. Do some kids not like to be touched? Are some kids overly sensitive to noise? Do some kids not like to shift from one activity to another? So you've got to give them a little bit of a warning. Instead of just saying, stop drawing that picture, we're going to do science now. You maybe say something to them 20 minutes ahead of time. That's what an FBA does. It looks at behaviors that you want to stop and what causes those behaviors. And then there's supposed to be what we call a BIP, which is a behavioral intervention plan. And what that is a blueprint to figure out how to stop the behaviors. We had a young woman who had Down syndrome, and she had very large mammary glands, and she kept taking her shirt off in the middle of the classroom, which is clearly inappropriate. But it turned out that that was the only time anybody would talk to her, all right? And she had figured that out, all right? That I'm sitting here all by myself, I'm being ignored, but if I take this blouse off, somebody's gonna come and talk to me, all right? So when they did the functional behavioral assessment of her, and they realized that that's what the problem was, they got a plan going to say, talk to her, you know? Somebody go over and engage with her every 20 minutes, and then she won't do that just to need attention. Because kids with disabilities sometimes do things because of their disability. We are still trying to figure out how the Massachusetts law overlaps with the federal law, because before July, everybody could get excluded for 10 days, all right? And nobody was entitled to any educational services during that period. That is no longer the case in Massachusetts. The question is, do kids on IEP get the IEP supports for those first 10 days, or do they just get some support? And the answer is we don't know. We're waiting for guidance on that. But the important thing to remember is that if your child is on a signed IEP and the school excludes your child for a disciplinary violation for more than 10 days, they are supposed to do the MDR. And if there isn't already a behavior plan, they're supposed to do a functional behavioral assessment to develop a behavior plan. Can I have the next one?
Oops.
This is the MDR, and I want to just emphasize this because I think a lot of people don't know about this, and they don't know that they have a right to prepare for it. An MDR is a meeting where you get to come, you must be invited, and you have a right to explain to the team the connection between your child's disability and what it is that your child did. If your child is sitting in the room fidgeting and making noises, and your child has ADHD, or your child has Tourette's, or your child has a mood disorder, it's very likely that the disability and the conduct are connected. And you have a right to establish that and to say that to the team. You can bring support, and if you're not ready because you don't have all your proof lined up, you can ask to reschedule so that you can get some time to prepare. The significance of this is that if they determine that the disability and conduct are related, your child should be returned to school after the 10 days, all right? Your child gets to go back to school, all right? Your child also is supposed to get supports as a result of the functional behavioral assessment and the behavior plan to see if they can devise a strategy so that your child doesn't do the same stuff all over again. So the MDR is going to ask, did the disability cause the behavior? Was there a direct and substantial relationship between the disability and the behavior? Or did the behavior happen because the school didn't follow the IEP? So it's very important to look at that IEP, because if the IEP says your child is supposed to get 3 days of counseling so that she has somebody to talk to, and as Hillary was suggesting before, maybe the counselor's on maternity leave, or for whatever reason there was a scheduling problem and your child didn't get that counseling, maybe that's why the child didn't get enough supports and was more inclined to violate a school rule. So you want to see whether there's any connection between the failure to deliver an IEP service and the behavior that occurred. FBAs and BIPs are explained here. An FBA is an observation to determine the cause of behaviors you want to change, and those are called the target behaviors. The BIP is something that should result from the FBA, and it's a blueprint. It's a series of strategies. Talk to this young woman who's taking her blouse off every 20 minutes so that she gets some attention and she's connecting with people, all right? Understand that there are strategies for some kids who don't like to be touched. You need to tell them ahead of time. You know, we've got colleagues sometimes who are blind, and they'll tell you that people have a tendency to touch them because that's their way of thinking that they're making eye contact, and you don't think that this person can't see you. So all of a sudden, you know, your hand is on the person's shoulder and they didn't see you coming, and some people are going to react very adversely to that, as opposed to just saying, hey, I'm in the room and I'm about to approach you, all right? So there are lots of things that you can learn just by observing somebody and getting some sense of what the triggers are to certain kinds of behavior. FBAs and BIPs are required under federal law, not Massachusetts law, for kids who are excluded for more than 10 days. That means a suspension. That means calling you on your job and telling you to come get your child because your child is acting up and the school can't control him when it's the school's idea and not your idea. It may involve an in-house suspension if there are no books in that room that they send your child to. If your child shows up at 10 o'clock and a teacher gets angry with her at 10:30 and says, go to the, what do they call it, the quiet room or the thinking room or whatever they call it these days, and there are no books in that room, and your child is in there all day, we as lawyers for students argue many times that that's a suspension. If you are told to come get your child and remove your child from school, and they don't give you a suspension notice, you need to think about writing to the school to say, this is to confirm that you called me on Thursday, October 23rd, and told me to come pick up my son, and I did it. So I'm considering that a suspension. You want to be able to create your own documents because counting the days is very, very important. And we talk to lots of parents who say my son or daughter is suspended and they can't tell me how many days, or they can't prove it because the school did not write a suspension notice. Okay, let's go. I want to talk a little bit about transition. Is there anybody here who has a student they care about who's 14? Whoa, okay. Transition services are legally required services from the school to your student to prepare your student for life after high school. In Massachusetts, this process is supposed to start at age 14. There's a transition planning form, ma'am.
I just want you to know this transition services will be covered next month in full, so I know you want to
Okay,
touch
that's
on it,
super.
but-
Then I'll be very brief. You want to sit down with your son or daughter at home and say, what do you want to do when you're not in school anymore, all right? Then you want to figure out what skills your son or daughter needs, like telling time, managing money, traveling on the T. You want to ask the school for assessments. You want to be certain to look at the IEP to see what graduation date the school is suggesting. Because if you disagree with that date, you want to disagree in writing and say, I think my child needs a couple of extra years in school. We have an online manual that tells you everything you want to know about transition, and that's the link. It's got videos. You know, Hillary ratted on me and said I'm in one of them, but she's in one of them too, explaining adult services. I do the one on dispute resolution in a different suit. Bad hair day though. There are other things, they're in Spanish and they're in American Sign Language. The videos are a little amateurish, but the information is fantastic, you know, because they're by people who really know the subject matter. We just didn't get any Hollywood training. You want to plan for your student's 18th birthday and be very aware. She is a legal adult in Massachusetts at age 18. And on her 18th birthday, you have no right to request any records, to be invited to team meetings, to talk to anybody at the school unless you have prepared in advance. In certain circumstances, you might petition for full guardianship, but that's not right for lots of students. They just need a little help. The same help you've been giving them for 17 years. What you need to understand is that when they're 18, they are on their own legally unless you take some steps to prepare for that. And we've given you a form called the Delegation of Educational Authority. And that form is something that your student can use to either give educational authority to you or to share educational authority with you. It's not a guardianship, all right? The kid can still go take the car or wear green nail polish or dye her hair purple or do whatever else she wants to do. But the point of this is that you can still stay in the game to help make educational decisions. And the kid can get mad at you and revoke it at any time. It's not like a guardianship. But it is a very, very useful tool when you have a student who's going to continue to need your help, but who may have passed his or her 18th birthday.
It's getting late, so we're going to go really quickly, and it's helpful to know that transition is being fully covered on another type. So 688, actually, can I ask, is the transition going to cover 688?
It'll touch on it, it won't be too in-depth, but we're also having resources come to the resource fair in January that will talk about 688 and have people representing that issue.
So we won't spend time on this. Again, if people have questions about it, I'd be happy to answer them. But just very quickly, Chapter 688 was the chapter of the law, but people just call it Chapter 688. This is a referral process for students who are going to require services after they leave special ed. So if they're going to need services from DDS, DMH, Mass Rehabilitation Commission, MRC, Mass Commission for the Blind, Mass Commission for Deaf and Hard of Hearing. So if they're going to need services post 22, usually we're talking about kids that maybe have stayed eligible until 22, then they're going to go through this process. And it's really just the school district makes a referral to who the district and hopefully the whole team thinks is the most appropriate adult service agency. And it is supposed to be at least a 2-year planning process. Oftentimes the district will send the referral earlier than the 2 years. The agency that receives the referral is going to very likely be responsible for developing the individualized transition plan and ITP. You can go to the next slide. I don't want to spend a lot of time on this except to really emphasize that this is not a continuation of special ed. This does not determine eligibility for adult services, and that's, I think, the really important part of this. All this is it's a referral. It's a school, you know, they make a big deal about the 688 process. All it is a district making a referral to, say, DDS. This does not mean that your child is automatically eligible for DDS services. You will have to go on your own to apply for adult eligibility for example, DDS services. What this does is it lets the DDS, the adult service agencies, know what students are coming their way. It allows them to be able to plan for the budget that they're going to ask the legislature for, that type of stuff. And the referral does not entitle you to any adult services. So just very clear that, you know, there will be a discussion of Chapter 688 if that's appropriate for your student once they hit the later years of transition, but just know you still have to apply for eligibility for services on your own. And those are just the lists of the acronyms for the agencies that we talked about. I will just point out the last one, BTP is the Bureau of Transition Planning. That's the bureau that oversees the 688 process. So if you're having problems in this process, like the school didn't make the referral, or they made the referral and you applied as you were supposed to, but your kid's been denied eligibility, and say you applied to DDS and DMH and you were denied from both, and now you don't have an agency in this process, and it's unclear who's going to be developing the individual transition plan as you move towards whatever adult services your kid's going to get. So if you're in that situation, which is very difficult and unfortunately happens more than it should, where your kid's been denied from all the agencies that would be appropriate, then you probably are needing to be in touch with the Bureau of Transition Planning to really kind of work out that this is somebody who needs long-term supports and services, so an agency is going to have to be assigned. And now, since we're talking about transition, we're not going to talk about that anymore, and we're going to go on to bullying very quickly, very quickly, and then it'll be time for any questions that anybody have. You know, many people probably know that there was a bullying law passed in this state in 2010. It was a pretty well publicized thing. It's a pretty comprehensive bullying law. It obligates school districts to do a lot of things. The enforcement of it can sometimes be difficult and frustrating for parents, but you know, theoretically it's a very comprehensive law, and it really does put some good things into place. So every school has to have a bullying prevention plan, which hopefully you know about, hopefully they've told you about. They're supposed to do that. If they haven't, it should be on their website, the whole plan, or you can request a copy from your school district. The bullying prevention plan that every school needs to spell out what their investigation process is, because you can make a bullying complaint. You can do it verbally or in writing. We would very much emphasize that you do it in writing. But if you make a complaint that, you know, Joey is bullying my kid Sam, they have to investigate that, and they have to follow their procedure that's in their bullying prevention plan. If they substantiate the bullying claims, then they have to tell you kind of what's being done to rectify the situation. It gets a little sticky when, say, you know, Joey's bullying Sam, school agrees, Joey is bullying Sam, this needs to stop. Joey has been suspended or disciplined in some type of manner. That is Joey's and his family's confidential information. That is not something that Sam and me, as Sam's mom, which is a fictional child, don't have a child named Sam, but I do not get a right, I don't have a right to know the number of days that Joey was suspended, or, you know, what is going to happen to Joey when he comes back to school. I don't have a right to know that. I have a right to know what's going to affect my child, and if there's changes in my kid's IEP to help put you know, supports in place for him, to make sure he's getting enough work and social skills to be able to to work on his own ability to identify bullying behaviors, if that's something that he would need. I have a right to know that. I don't have a right to know everything that's happened with Joey to rectify the situation. Be careful if your child is a victim of bullying, school substantiates it and says, yep, this is a problem. Be careful that what is done for your child is not putting your child in a more restrictive environment, unless for some reason that's appropriate. But this is a whole LRE thing. Your child's entitled to be in the least restrictive environment. So if there's an issue in a classroom and there's the bully, the perpetrator, and then there's the victim, the bullying victim should not be then pulled out and put us into a substantially separate classroom to get that kid away from the bullier. Not what should happen. So just be careful if that's something that looks like it's going to happen. Next slide, things that you can do, report right away, really do it in writing. The law says verbal complaint is enough, but, down the line, how do you prove that you made the complaint? You prove it if it's in writing and you've kept a copy of it. Be specific, just being really vague about it. That's really hard on the school. They have to know what's the alleged, incident that happened, who were the bullies, who did it, what did they do, and then, if it's a really pretty serious, stuff going on at school, you really might want to talk to the team about developing a safety plan. Whether that's identifying a safe person at school that your son or daughter feels comfortable going to if there's issues happening, or maybe they need to be essentially like monitored in some way, which is very restrictive on your child, but if it's a real safety issue, then that could be part of a safety plan, is that there's really essentially a one-to-one kind of following them around, maybe in the hallways to make sure that they're safe, things like that. And that's all that we have for substantive topics. Many of those topics could have been 2-hour presentations by themselves, so we apologize, or I apologize, Pamela it did wonderfully.
Never apologize.
I apologize if we rushed through certain parts or some parts were unclear. It's really trying to put a lot of information in one presentation. So please ask questions if anybody has them. Yeah, sure.
I just want to reiterate what you were saying earlier, the PQAs. If I have an IEP that's buffering and nobody's picking up the ball through several different schools, I call the I write the PQA.
What do you
Nathan Lemon.
Yeah.
Can I get his phone number?
Yes.
So
Sure.
I can.
Did you hear that in the back?
Yep. Thank you. Yep. And if people have questions that they'd rather talk about personally, that's okay too. If it's private, I get that. So we'll be here. But yep.
As far as parents,
Oh wait, there's still a couple more questions. Sorry. Just go ahead.
as far as like parental guidance for IEPs, do you have any literature or books you recommend?
That's on the website.
Yeah. What?
Niche.
Yeah, there's some stuff on our website. I would also recommend the Federation for Children with Special Needs is an agency in Boston that their website is so packed full of information, different guidance for IEP goals, all of that. That's a good site.
I do Google. I do regular Google IEP goals, and it pops up all kinds of stuff.
Your professional opinion,
Yeah.
stuff. If you had any,
Like a particular book or something.
one that said, "I really like this. It's
Yeah.
really good. You should read it."
Google, because it's got all kinds of links. No, I'm not being the least bit facetious. There are organizations that do sample IEP goals and write them out in ways that are clear so that you can figure out later on how to measure somebody's progress. And I find all of that on Google.
Also, if, there's a disability-specific organization, so, I have a brother that he has Angelman syndrome. It's really rare, so, it's kind of hard, but if you have a kid with, dyslexia or Down syndrome or, autism spectrum, there's all disability-specific organizations now that you can go to their website and they'll have suggested IEP things as well to kind of key into your kid's profile, so that's another one. Yes?
They're saying that the child needs to be currently in an inclusion program.
Yeah.
They're saying she needs to be in a substantially separate program. But there are kids in the current classroom that are more disabled than she is, and, retarded. She's not retarded, she has and they're saying that she needs to go to a substantially separate classroom. Can you ask her, or you don't know their name, but just what level the students are in the class?
in the substantially separate class that they're recommending in our current class. Yeah, I mean, you can, there's a couple things. First of all, every kid's IEP is individualized, so it's kind of hard to say, this kid has this disability, so I don't think my kid should be in their class. It can be a little difficult. But you can always, you have a right to go in and observe, so you can go in and observe yourself. You can ask for general information about, saying you have concerns maybe about appropriate peer groupings, to ask for kind of general information about that. But they're not going to give you, Sally Jones has Down syndrome, because that's personally identifying information.
Can they give you the information de-identified?
Well, I would say it depends how large the class is and if there's a risk of it being personally identifying information. It's why you might want to go in to observe with your own eyes. It might be an easier way than trying to kind of argue back and forth about what could be construed as personally identifying information. That'd just be a practical suggestion of that. Yeah.
So, I recently went through mediation and signed the mediation agreement.
Yep.
However, before the school year ended, I rejected the IEP in full, the current IEP, but I signed the mediation agreement. So what happens with the rejected IEP? Do I not need to, because there's a mediation agreement in place, but it's only, the mediation agreement only touches on a certain service, not on the other services that were covered in the IEP?
You want to go? Go ahead.
You rejected a complete IEP, and then you went to mediation that resolved one issue. So the question is, was there an IEP before the one that you rejected in place?
Yes.
So my guess would be that the last agreed upon IEP would cover all services, and then whatever you agreed in the mediation would supplement that. That would be my guess.
Yeah. Any other questions?
Thank you for coming.
Okay, thanks so much for staying. It's a long time. Oh, I totally